So there have been some important developments in a lawsuit which aims to remove state bans on the purchase and possession of suppressors. So let's talk about what is happening in this critical case. Now, before we jump into this video, I want to thank the sponsor of this video, which is Silent. Now, let's face it, we all know that our phones and other electronic devices like laptops are actually just tracking devices. Big tech, government agencies, and even cyber criminals, they're all collecting our data, and they're doing that through some of our devices. That's why it's always a good option to maybe look into, Faraday bags and other options, and I highly recommend Silent. Their Faraday gear and these bags and other items you can get block all wireless signals, cellular, Wi-Fi, Bluetooth, GPS, and a lot of other signals that, government agencies, hackers, all these people use to get into your devices. I use their backpack every single day when I'm going to and from the office. I put my laptop in there, my phone in there, and then also I use it a lot when I'm going through airports or when I'm staying at hotels because, again, I want to protect those devices and I don't want people to get access to my devices, to my phone, or to my laptop. So again, if you're interested, you can protect your privacy, your freedom, and all of your family and your devices by just simply using a Faraday bag. I highly recommend Silent. You can go to silent.com/scholar and you can get 15% off and a free shipping as well on these products. Again, simply just go to slnt.com/scholar. And again, I will link that all down below in the details section and also in the pinned comment. As I mentioned in the intro, in this video, we're going to be discussing a new suppressor decision which was issued in 2 lawsuits, and these lawsuits aim to remove a state ban on the purchase and possession of suppressors. The case that we're going to be talking about in this video was a combined lawsuit. 2 cases were combined and consolidated. Those were Morse versus Raoul, and then also Anderson versus Raoul. These lawsuits are important because although most states allow for the ownership of suppressors, there are 9 jurisdictions within the United States which actually don't. These lawsuits could be the first in the nation which actually find that states cannot outright ban these types of NFA items like suppressors, and to do so is unconstitutional. However, in this case, the district court recently granted a motion to throw the case out completely, and that was requested by the state of Illinois. The court found that there is no history or tradition to show that suppressors are protected arms under the Second Amendment. Therefore, the court ruled that plaintiffs in this case failed to state a plausible Second Amendment claim. However, these cases are far from over. The plaintiffs have appealed this case to the 7th Circuit Court of Appeals, and they're asking for a reversal of that lower court ruling. They argue that the lower court got the decision wrong by claiming that suppressors are not protected arms since they did not exist at the time of the founding. Now, this lawsuit again is important because it tries to use the Supreme Court's recent ruling in New York State Rifle and Pistol Association versus Bruin to attack a state ban on the purchase and possession of suppressors. In Bruin, the Supreme Court issued an opinion which was authored by Justice Thomas, which struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruin in that ruling was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. This lawsuit here, dealing with suppressors, aims to finally make a state actually explain how an outright ban on suppressors is consistent with our nation's history and tradition. However, in this recent ruling by the lower court seemed to flip that burden and apply it to the plaintiff instead of the state of Illinois. The Illinois federal court ruled that plaintiffs did not show that there was a history and tradition to support their claim that suppressors are afforded two-way protections. In the Anderson lawsuit, the plaintiffs argued that the Second Amendment's reference to arms does not apply only to those arms in existence at the 18th century. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, they state, even though the Second Amendment's definition of arms is fixed according to its historical understanding, the general definition covers modern instruments that facilitate armed self-defense. So the argument by the plaintiffs was that suppressors are still protected even though they did not exist at the time of the founding because technology advances, and we know that the rights evolve with technology just like the First Amendment evolves with new forms of communication. The Second Amendment evolves also with modern arms. However, the state of Illinois argued that suppressors are not protected items since they did not exist at the time of the founding. And ultimately, the district court agreed with the state of Illinois. The court ruled that while modern innovations can fall under the Second Amendment if they are modern versions of historically recognized arms, there is no historical tradition or precedent, according to them, showing that devices designed to reduce the sound of firearms were ever considered arms at the time of the founding. In essence, the lower court found that the modern item like a suppressor can only be protected if there is a historical analog that you can draw a parallel to. That is not something that the Supreme Court stated in Bruin, but the lower court here kind of created their own test, saying that an item, a new item or a new technology is only protected if you can draw a parallel to one that existed at the time of the founding. The district court found that since silencers are accessories rather than weapons themselves, and plaintiffs could not point to any historical analog or evidence that silencers were part of the original understanding of arms, the plaintiffs failed to state a plausible two-way claim, and therefore it granted a motion for judgment on the pleadings in favor of the state of Illinois, and because of that, they threw the entire case out. The lower court stated that the plaintiff's complaints and the record are devoid of any reference to a time in the history of our country where an earlier generational device, accessory, or attachment was broadly employed to reduce the report of a firearm. Put another way, they stated, plaintiffs offer nothing to suggest that there is a fixed historical understanding that devices which serve only to enhance operation of a firearm by reducing its reports are arms themselves. They state simply, if there was no colonial era or antebellum period archetype to a modern day silencing device, it is difficult to understand how the framers would have understood the ordinary meaning of the word arms to include a device that reduces the report of a firearm. The court went on to state that at the same time, some attachments are so integral to the effective operation of a firearm that they might be logically included within the historical fixed understanding of an arm. For example, they state, as mentioned earlier, there have been seemingly significant technological advances in firearms to aiming technology from periods where no sighting devices were used, progressing to things from iron sights all the way to modern sophisticated optical sights and red dots. They stated that while some may argue that sights or larger magazines are just accessories because they are not essential to the ownership and function of a firearm, such attachments might be considered arms because they are modern versions of historically utilized firearms components that existed prior. So this was a very interesting ruling by the lower court and kind of the first of its kind that was issued by any court. The judge took Bruin to say that an item is only protected and it's only a protected arm under the Second Amendment if you can show that there is a historical precursor to that item that existed at the time of the founding. If the modern firearm or item does not have a historical precursor dating back to 1791 or potentially closely after, it may be unprotected. The only way to carve out that is maybe the firearm technology has become so necessary and has advanced to such a point where it's so needed for our modern arms that are common use for lawful purposes, to where they by some way become a necessity and because of that are protected. So this line of analysis is very concerning to me and potentially opens the door to a lot of items losing to a protections if you cannot show a historical precursor that existed at the time of the ratification. However, I will state this case is far from over. The plaintiffs have now filed an appeal to the 7th Circuit, so now this will move up the chain to the Court of Appeals. There are currently other cases filed in other federal courts challenging bans by states like New York and New Jersey, and there's also one in California, all of those dealing with those state bans on suppressors. However, this one will be very important because it's now in the 7th Circuit. It's kind of the highest one up out of all of these cases. And I have no doubt that the state attorneys in all these other cases out of New York, New Jersey, California, and all these other states that have these types of suppressor bans, they're going to cite heavily to what just happened in this lower court, saying that there is no historical precursor for these types of items like suppressors to be protected arms. So this is a case and issue we will definitely be keeping our eyes on because this ruling and analysis is going to impact other cases, and now it's heading to the 7th Circuit for re-review. Again, a very important case challenging the state of Illinois' ban on suppressors and bans on these types of NFA items. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to like, comment, and subscribe. You can also check out one of these two videos here on the screen that the YouTube algorithm thinks that you will find important to you or educational. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.